This courtroom is about to unravel stories of repeated violations, second chances squandered, and defendants who think they can outwit the system. Today, we'll watch Judge Vallow and prosecutors face off against individuals who've struggled with alcohol, tether violations, and reckless decisions that put public safety at risk. You'll hear excuses about broken phones, church meetings, and even a tether getting caught in a bicycle pedal. But will those excuses be enough to keep them out of custody? Stick around, because each case raises the same haunting question. At what point does leniency become too dangerous?
Good afternoon, Your Honor. Constable Bates on behalf of Mr. McFall, who was present to my right. Can you state your full name for the record, please?
Floyd McFall.
Your Honor, today is the date and time set for PCC. At this time, we're going to be requesting to set this for an exam.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available on the 9th.
Yes, Your Honor.
Preliminary examination in person, September 9th, 2025, 9 a.m. That's before
Judge Vallow.
Judge Valvow. We've got, you want to address the violations now?
Yes, Your Honor. I did speak with my client about the violation. He did attempt to turn himself in twice, and he was told that there was no warrant. Him and I spoke about it in depth. He understands how serious it is. Your Honor, if the court is willing, maybe to put him on a scram tether, and he will have no further violations in this matter. He's just asking for one more chance, Your Honor.
Notice how defense counsel emphasizes that Mr. McFall tried to turn himself in twice. On the surface, that sounds responsible, but prosecutors quickly cut through it. The violations weren't just misunderstandings. They happened on 3 separate dates. And here's the kicker. Alcohol is at the center of all of them, which is especially troubling since the alleged weapon in his assault charge was a wine bottle. Think about that. How much weight does turning yourself in really carry when you can't stay sober long enough to comply with bond?
Response from the people.
Your Honor, we have concerns about this fall allegedly drinking. I would note that it's not just one incident, it's on 2 different days, and that the report indicates that when Mr. McFall was questioned about the August 19th date, he admitted drinking, but then we have an August 24th date. So,
And also an August 26th date. It's on, that was, you may not have, well, you should have. There was one report on August 20th, which has those 2 on it, I think. Maybe not. No, the 19th, and then he drank on the 24th, but then further down, he also then blew and numbers on the 26th. But there aren't any other readings because he didn't take the follow-up test.
and so, Your Honor, part of the reason that we find it concerning, believe that alcohol related fall with this, and that as far as the felonious assault charge, the alleged weapon is a wine bottle. So that's what gives us some concern. So I don't see why an alcohol tether is going to somehow ensure that Mr. McFall applies with bond conditions that he seems to have violated them multiple times when he was confronted.
Well, Your Honor, in response, although a wine bottle is allegedly involved, that's because these allegations took place at a store. He was not drinking at the time. There was no, I don't believe there was an alcohol test taken at the time of arrest. So there's not really a substance abuse problem involved. And I would say that the tether would be a constant reminder that if he does end up drinking, he's going to be remanded.
So blowing into a machine doesn't do that?
Well, Your Honor, I think the tether on his leg is and I've had serious conversations with him, Your Honor. He's just asking for one more chance. He's here today. He understood that there was a warrant for his arrest. He still came in.
This is the moment where the judge directly tests the defendant's sincerity. Are you in treatment? His answer, just at my church. No proof yet, Courts hear this line often vague commitments without documentation. In law, proof matters. Without signed attendance sheets, treatment center records, or AA verification. Judges see these statements as last-minute attempts to dodge consequences. Viewers, ask yourself, if someone truly wanted recovery, wouldn't they show up with evidence ready? Or is this just courtroom theater?
He did try to turn himself in a couple days ago when I originally told him that there was no bond warrant. He does want to move forward, Your Honor. He's just asking for another chance.
3 occasions. Is he in any treatment or anything at this point?
No. Just at my church, I don't have proof for it though. And I did sign up for AA. I took like a hour-long test on it. I just got to get into.
Okay. Well, it looks like he is working on that, Your Honor. He's signed up.
Working on it.
Yes, he's signed up for treatment.
Between drinks. Bond revoked, defendants remanded.
And just like that, the hammer falls. The judge revokes bond and orders the defendant remanded. Notice how quickly things shifted. 1 minute, the defense was begging for another chance. The next, the judge shut it down completely. This illustrates a key principle of criminal law. Bond is a privilege, not a right. Violate it, and the court will not hesitate to pull you back into custody. The courtroom atmosphere here almost freezes. Everyone knows this isn't just a warning anymore.
Your name?
Melissa Kalminski.
All right. What are we doing on this case?
Your Honor, we're asking for an adjournment for negotiations and to review videos.
You've seen the bond violation report.
Yes, Your Honor, and we have discussed it and I'm ready to address it when the court is ready.
Yes, I'm ready to address it.
Ms. Konowinski stated that she did drink, but it was only that one day. This was a one-day slip-up. She didn't take the test within 15 minutes because she fell back asleep. She takes mental health medications at night, which has been reported to CMH, which make her fall asleep. She wasn't avoiding calls. One of the numbers that she gave was her boyfriend's number, and he said that he didn't receive any calls. The other number no longer works. She did believe they have her current number, but that phone only worked on Wi-Fi, but she recently got it switched to a phone with a SIM card, so now works all the time. This Saturday, the 30th, she returns to work at Dunkin' Donuts. On the 11th of September, she will start a part-time inventory job. She also receives her Vivitrol on the 11th. On September 22nd, she has an appointment for mental health addiction recovery and an evaluation with IHA Trinity Health. She has been going to AA and has proof. Her letters of recommendations from
How long has she been going to AA?
She has the proof. How long have you been going?
I've been going over a year. It's a sunshine group. But since I've been out of rehab, this is what I have.
When did you get out of rehab?
I got out on the 15th,
Of what?
August.
And she does acknowledge that
Started drinking by the 19th.
that was one day
One.
after. And since then, she has been testing negative. She has letters of recommendations from Bear River Health and one from her boss. She volunteered in Hanover, Michigan at Rust and Dust and has a letter from there also. She realized she slipped, and for the first time, she wants this court to know she caught herself and immediately got back on track. And normally when she slips, she goes on a bender. Ms. Konowinski is asking for more time to test instead of twice a day so that she is more accountable to herself and to the court. We ask this court to recognize that she had no violations after that date and to give her another chance, especially since she has appointments set up for her mental health and for her addiction. She is also here today knowing that she could be remanded. She would also like to address this court.
This is a powerful human moment. Melissa thanks the judge for evicting her from her ex's house. Admitting it likely saved her life. It's rare to hear such raw gratitude in a courtroom, but pay close attention. Within days of leaving rehab, she was drinking again. Addiction has that vicious cycle, moments of clarity followed by devastating relapse. The defense frames this as a slip, but prosecutors will soon remind the court just how dangerous that slip really was.
Good morning, Your Honor. I first off want to thank you for back in December of evicting me from my ex's house. I'm glad that you did. I did not want it because that was a safe spot to drink. And since being evicted, things have changed. It's come into a lot in my life. I don't have to be in that household with him. And for that, I thank you very much. During the eviction, I was scared because I was giving up my way of drinking. And to this day, if I would have still been there with that man, I would probably be dead. So I thank you for giving me the eviction. And I do acknowledge and admit my part in this addiction and what I did. I'm not saying it was right, but I want to be fully honest with my recovery completely with sobriety because I don't have any more to give.
Response from the people.
This is an overview I heard with 2 priors, both in 2021. This was a hit and run crash where the defendant was then located driving a vehicle with heavy front-end damage. She was so intoxicated they couldn't even do the field sobriety test. Eventually, her blood test showed she was a .280.
Here's the gut punch. Prosecutors reveal Melissa was driving with a blood alcohol content of .280 after a hit-and-run crash. To put that in perspective, .08 is the legal limit point. .280 is over 3 times that. At this level, most people can't walk straight, let alone drive a car. Prosecutors hammer on public safety, and rightly so. This isn't about personal struggles anymore. It's about protecting innocent people on the road. Viewers, what do you think? Should relapse excuses matter when lives are at stake?
I have no faith that she can be safe in the community right now. I'm extremely concerned that Evo and described Heather, given the levels that we see in the SoberLink testing, and I also know from the court, I'm sure the court's already seen it, it's towards the end of her testing window. So that leads me to have suspicion about what was it earlier in the day. I'm extremely concerned for public safety. Should she be released at all? I would ask that her bond be revoked and she be remanded. If the court is inclined to release her, I would absolutely request a scram tether. I don't think SoberLink is going to be sufficient to public safety.
And Your Honor, I think she would be okay with that if she did ask for more times to test so that she could be more accountable to herself and to this court.
And Your Honor, I have to go back to that. I don't think more times to test is going to be an adequate solution here with somebody that's at a .28 crashes, runs from the scene and has 2 priors.
Let me clarify. I was saying that she would be okay with the scram tether.
He's currently in some type of program.
She starts her program on the 22nd.
IOP, intensive outpatient.
IOP, intensive outpatient.
When?
September 22nd. She starts testing.
Do I have that? Is it somewhere in writing?
I have it on that.
She emailed it to me. I can send it to the court.
Well, you can send it to the court along with some order. There's got to be some structure. If she's not going to be in an IOP, I can't take the chance that she's going to go on another one of these, hop into a vehicle, and this time take somebody out. I can't do that.
Well, Your Honor, she has been negative, and that was just the 1 day slip up.
Yeah, but that's all it's going to take.
I understand.
She's got, this is her third.
I don't have a vehicle. Don't have a car. And I'm going to church and I'm doing AA and I volunteered. And I know what it looks like, but I wish people could see why I drink. To see the abuse and to see everything I went through. Why the hell I was living in.
I get all of that. The problem is that what's going to happen outside of the alcohol, you could potentially end up killing yourself just from the alcohol. But then all it takes is one of these slip-ups and somebody else goes. Somebody who had nothing to do with any of that abuse, had nothing to do with anything. They're all of a sudden wrapped into your world and your tragedy that you've been suffering. I get it.
I understand that. But I haven't drove in over a year or 2 years. I'm willing to go with alcohol tether, and I'm fine with that, Your Honor.
And Your Honor, she now keeps in contact with me as a support system. He calls me weekly and we talk.
And I have like letters.
Got to put together something. I'll consider it next week in terms of programming or something like that she's involved in.
Okay.
But
I do have IOP set up. I do have it set up with Medicaid rides and everything. I've been really working hard since I've been out to get back on my feet.
Gonna happen again. Defendant's bond is revoked during the probable cause conference, September 4th, 2025, 9 a.m.
Yeah.
Okay, September 4th, Your Honor?
Yes.
Thank you, Your Honor.
Your Honor, today is the date and time set for probable cause conference. At this time, we're going to be asking for an adjournment to continue negotiations, as well as give my client some time to hopefully pay off some of the restitution in exchange for a better offer.
Before I set the date on an adjournment, she has a no bond warrant.
Yes, Your Honor.
Address that.
As to the violation, Your Honor, my client still has the tether on her leg. As to the explanation, Your Honor, she tells me she was riding her bike and the tether got caught in her bike and like with the pedal. So she kind of had to adjust it. She lives far away from community corrections. That's why she wasn't able to go in
I have
and
a
get
broken phone too. I had my number to the tether guy in my phone, and I had no way to contact.
So the tether came off in a pedal.
No, it's still on. It just pulled it and it poked it. Like there's something poking through
Did you
it.
call community corrections at any point?
That's what I'm saying. I was able to. I didn't know who to call except for the tether officer, Mr. Levitt, but it was saved in my
Was
phone.
your tether
which
going
was
off?
broken. It was going off, but I was on my bike and I was kind of scared, so I wasn't sure where or what to do. I did call my mom right away. As soon as not call her, but I went to her work. I rode my bike to her work actually, and tried to use her phone, but I wasn't able to while she was using it for work.
So if you didn't know where to call, what were you gonna do with her phone?
I was gonna call the public defender, which I did. I was able to email someone that following Monday because it was on a Friday, but I did text Hannah Mackey from the public defender that night when I was able to use her phone, explaining that there was an issue and that I didn't have a way to contact. And then when I did finally get a hold of him, and left a message out until tomorrow, I think, but I was waiting for someone to contact.
Did you go to the community corrections?
I called them. I did when I finally was able to figure out who to call when I got the email.
When did you call them?
I called.
How many days after this alarm went off?
Well, it happened on Friday, and then I got the number to call the community corrections that following Monday. I called and left a message for Mr. Levitt. I think I left the message actually today.
Your Honor, I just want to say that this is a tether was put on because I believe for a previous failure to appear, and she is here today, Your Honor. So it shows that she does want to comply with the court order. She does want to be here. She does want to handle her case.
But she doesn't want to comply. Have you been to community corrections at all?
Now, let's talk about the bike tether excuse. The defendant claims her ankle monitor malfunctioned because it got caught in a pedal. But the judge and prosecutors aren't buying it. Why? Because tether devices are designed to track tampering. Any unusual activity sends alerts. Plus, she admitted she didn't even call corrections until days later. In law, this is called failure to mitigate, not doing everything you can to fix the problem. And in bond supervision, excuses often equal.
No, I live in Jackson. I was lucky to get here today. I wasn't even sure what was going on. I don't have a vehicle, or a phone at the moment. So I was requesting things through email as well, or trying to. I'm still charging it as well. Like I'm not trying not to.
She's not trying to abscond, Your Honor. She's not trying to disobey the court orders. It seems it was just an accident. And just due to her lack of efficient communication method, I think that's really where the problem lies.
I have an old tablet from 2015, I think, with Wi-Fi for communication right now.
And when I reached out to her and let her know that she would be required in person because she initially tried to attend via Zoom and put in a request via Zoom, she did her utmost to make it here, and she's here, Your Honor. So.
Yes, but I don't
have a
understand why she didn't.
She hasn't even secured a ride back yet today, so
Yeah.
she her transportation.
But why she didn't keep in contact more with community corrections?
I think it's due to
I mean,
her
this
lack
thing
of.
went off almost 10 days ago.
Well, I was
And we
waiting,
don't,
I'm sorry.
go ahead.
Apologize. I was waiting for someone to get back a hold of me through my mother's phone or through email because I wasn't sure and I was still charging it. So I honestly just assumed everything was okay. I know that sounds stupid when I say that out loud, but I didn't know what else to do as far as contact. As soon as I found out the information this morning, I did everything I could to make sure to come. And left another message on Mr. Levitt's voicemail, who will not be in until tomorrow.
The second page and what they suspect this defendant was doing is really alarming to me.
I'm not sure what that means.
Your Honor, I think that is mostly just speculation at this
Oh, I
point.
don't-
She still has the tether on. She's still been charging it. She's still.
What is?
And I don't think there's a hot zone to this tether, Your Honor. I think it's just a GPS tracking tether to make sure she comes back from court, is what I understood. And she is here today. So the purpose of the tether is being fulfilled.
Any response from the people?
Your Honor, when the court released this defendant in April of this year, the court gave her a chance. I had expressed concerns because she had 2 warrants out of Kent County, one for child support, one for an OWI third, if I recall correctly. And I was worried about seeing her again. The court gave her this tether as to track her location. So it is the people's opinion that strict compliance with the tether would be a condition of bond. So any tampering, anything like that. I noticed when the defendant was giving her recitation of what happened, she first said, I called my mom, and then very quickly said, I went to her work. Because she earlier had said that her phone wasn't working. So that is concerning to the people and something I picked up on. I think the court picked up on it too, as I called.
I did.
So I'm just worried about what's going to happen.
I don't think I'm being told the truth, in all honesty.
I understand.
Your Honor, I understand, but as I said, the purpose of the tether was for her to come back to court. I'm not sure why there's concerns if she's in court here today. And she's saying that she just misspoke because she's very nervous, Your Honor. She suffers from anxiety.
Probable cause conference will be adjourned to September 4th, 2025, 9 a.m. Defendant's bond is hereby ordered revoked. Defendant's remanded.
What we witnessed today is a sobering lesson in accountability. Both defendants faced choices treatment, compliance. On a stand, both stumbled with excuses the court simply couldn't overlook. From high back levels and hit-and-run crashes to tether violations explained away by bicycle pedals. The judge ultimately saw through the excuses and revoked bond. These hearings remind us that while courts may allow second chances, repeated violations slam that door shut. If you found this case as shocking as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Because in this courtroom, excuses don't last long, but consequences do.